What's up? What's up, everybody? Glad to finally be back. It's been a couple days, so um, there's been a lot going on, obviously, in the news, and there's all kinds of stuff that we could talk about. But seems like one of the biggest thing that's being talked about right now is all of the cease and desist letters that Turning Point USA is sending out to everybody. Candace in particular. Um, I know that they've sent out letters to, let's see, Wolves in Finance. Um, let's see. Seems like there's more. I just can't think of them right off the top of my head. So probably more to come. But Candace is the one that I want to focus in on the most, I guess, just because at the end of the day, if they pushed it all the way and ended up with court and anybody, obviously it could turn out bad for them. But I feel like if Candace ends up with discovery, it would probably end up being the worst for them. And hey, like the title says, could it be their undoing? I don't know. Maybe could be bad. So I've got I got a video I want to go through. Obviously, I'll pause it here and there and tell you some of my thoughts. Um, this guy is actually a new YouTuber also. Um, let's see, I can't think of his name right off the top of my head. That's bad. The Anthogenic Esquire. Um, he is really new. He just started. I guess right before I did. He's an attorney though, and he's pretty smart. And he kind of breaks the whole the whole process down. Um, the whole cease and desist letters, and the whole defamation thing. So I'm gonna get that started, and like I said, I'm gonna pause it here and there, and we'll talk about it. So.
With YouTube, so I'm not going to have the screen share function today. However, I have my email in the description. If you would like a copy of the outline that I created for this episode, for this live stream, I'd be more than happy to send you a copy. Incredible comments. Like, thank y'all so much. Thinking about those nice comments and people. Go check them out, Wolves in Finance, who's been doing some pretty incredible work and investigation around TPUSA, their nonprofit, their tax returns, the vendors, the outside companies they're dealing with, and has been doing, so again, just some really good journalistic reporting work. And so he was the first one to get a cease and desist letter. And we'll talk in just a second about what is a cease and desist letter, what do they do, things of that nature. And then Candace got one also. So Candace Owens.
And I want to apologize. Every now and then it gets fuzzy. That is not my connection. Not that mine could never do that, but it is not my connection. It was his connection. So not anything I can really do about it. So like I said, I apologize about that.
Also received a letter. Now, one important distinction here, and I'm pretty sure most people probably pick this up, but just to kind of review, is that Candace's letter was mostly based on a contract. So the contract that she apparently had with TPUSA many years ago, they're alleging that this clause that prevented her from saying damaging or disparaging comments survived the contract for a number of years. And that is true. That's a valid contractual thing, just so you know. Those things can happen. And so that's really how they kind of address her, was through the contractual angle, versus Wolves in Finance, who they obviously never had a contract with that we're aware of anyways, went straight for the defamation angle there. And so, but essentially what we're looking at is the same thing, right? Whether they're going after, hey, how you doing, Tally? Whether they're going after Candace, under the contract for her statements that she made, or whether it's defamation, Wolves in Finance, essentially the same, that, hey, there are these damaging, disparaging things that y'all have been saying through the course of your investigation, publishing them on YouTube and these other platforms, right? And so that's really forming the basis of these legal claims. So we're not going to go into the contractual stuff with Candace, right? We're really going to focus on the underlying defamation aspect of this. The impetus for this actual live stream is just me watching a lot of the videos, content creators and stuff talking about these letters. Not that they've ever said anything like necessarily wrong or incorrect or led anybody, but there's some important, let me say this real quick, is that defamation law is very dense and it can get very conceptually tough, just because there's a lot of nuance in it. And what essentially defamation law is, which, just so you know, it's a mix of two components. It's mostly driven by state law, but obviously because we have a right to free speech under the First Amendment, state law must yield to constitutional principles, meaning that state laws, what we call the common law, would provide a redress for people, basically laws where they could go to court and sue another person in that state for making defamatory statements that injured their reputation. They could go and sue those people and recover damages for the loss in reputation or damage to reputation. Okay. And so where we see the Constitution come in on this is obviously that, hey, well, sure, you can sue people in that state, but what if you're infringing upon their right to free speech, meaning that your lawsuit could prevent or punish someone from otherwise exercising a constitutional right, and we can't have that, right? So that's kind of the tension that we see in defamation law, is the state wanting to give redress, or the ability for redress, to its citizens, versus the federal Constitution, which has guaranteed all of us the right to free speech. So state law, which governs defamation law, varies state by state, but there's always that constitutional standard that they cannot go below, meaning that the state laws have to provide a specific and certain level of protection for people to speak freely. If they do that, then they're free to provide whatever other redress or specific procedural hoops or whatever they want beyond that, but there is a constitutional core that must be protected. And so when we're looking at defamation law, the way it comes out is resolving those two tensions, and periodically the Supreme Court has to step up and rule on a case that from time to time will require states to adjust their laws to make sure that it's congruent with.
And one point to always remember through all of this is that to sue somebody successfully for defamation, you have to have damages, and you have to be able to prove those damages. You have to be able to put a dollar amount on it or whatever, as to how much this person's commentary or whatever they've said, how much that has affected you monetarily or whatever. So in the case of Turning Point USA, I mean, I'm guessing that monetarily would be the direction that they would be going with that. And considering that, pre-September the 10th, Turning Point was a roughly 100 million, little bit plus 100 million a year company or nonprofit. And since that, they're at like $250 million. It's going to be really, really hard to convince a judge or a jury or whatever that you have suffered any kind of damages when you've literally made 2.5 times what, or brought in 2.5 times that you did the year before that. So that's just something to remember. I don't know how they would ever prove that they'd suffered any damages from any of these people's commentary.
Constitutional protections that are otherwise provided to people under the First Amendment. Okay, so that's kind of where we get the defamation law. So, and I want to say that to say this is that today my discussion of defamation law is not legal advice. Let me put that out there. This is not legal advice, nor should it be construed to be legal advice. This is simply an academic, general discussion of defamation.
Same here. I'm just doing a little commentary. I'm not a lawyer, not giving any legal advice. I am literally just telling you what I think.
Defamation law. Now, I'm licensed in Texas. I practice in courts all over the country, state and federal, but primarily licensed in Texas. And so I pulled out my Texas treatise book here, right? That talks all about Texas defamation law. Obviously, in there is the constitutional aspects of it too. So I pulled a lot of material from this. And so with that being said, I have to have a caveat that some of the stuff I'm speaking of could be kind of specific to Texas. But again, all state defamation law has this constitutional core. And so I did my best making my outline last night to make sure that my points are really based primarily in the constitutional aspect. Inherently, there's going to be some Texas stuff bleeding into here. I'll try to make that clear as I'm discussing, hey, this is Texas specific. Now, and again, just because it's Texas specific does not mean necessarily that that's not also applicable in your state. Okay. Again, there's this common constitutional core, and I've tried to keep my lesson today basically anchored to that more or less. So because the U.S. constitutional core applies everywhere, in every state. Joni, oh, thank you. Yeah, I hope y'all get something out of this. Like I say, I did it, for people who aren't content creators, just so that way you'll have an idea when you're looking at stuff hey, they might be, that might be bad. That looks like a light read, Pete. Hey, just so y'all know, these books, these treatise books are, I think I paid like $800 for this book 3 or 4 years ago. They obviously every year they have updates, stuff like that. This is actually, and this is I think 2 or 3 years old. But yeah, it's not a light read. They're great.
Oops, my bad.
Books. They're great books for a person who's a litigator practitioner. They're incredible. You can pick up these books and pretty much get filled in on the fundamentals and basics you need to know to litigate in these different areas. So yeah, this is a great companion, and I hope that the stuff I pull out today for this lesson will be beneficial for everybody. And then, obviously I want people in the community to be aware when they're looking at this stuff, exactly what they're looking at. Yeah, it's my first big upload speeds. I've been very minimalist. I'll be fully up in operation or fully professional. So I do appreciate it. And here to just shoot you straight. I don't have any Republican left right agenda, and really tethered to the Constitution when we're covering law, stuff like that. Okay. lives are great. I feel there's a good mojo for
right,
community.
let's
I
get
do
to
too.
covering it.
Yeah, no, I feel good. This has been a great community. I'm able to jump in and kind of fitting in so far. Here we go. And again, let me just with my disclaimer, this is not legal advice. And, you know, because for one, I don't know anyone's specific situation, so I can't give legal advice without knowing exactly what you're facing. But other than that, just general educational content here. So again, and this revolves around the cease and desist letters that TPUSA sent. I guess it was about a week or so ago. I talked already about the defamation law is the state common law versus the Constitution, First Amendment rights. You know, what we see in defamation law is really a reflection between those two competing interests. Let's see. Okay, so the three main points that I'm going to really talk about today in defamation law are one, well, I'm going to go over the elements, the general elements of a defamation claim, but then we want to talk about like what is an actual actionable statement in defamation, right? What constitutes something that is defamatory in nature and could serve as the basis for someone to assert a defamation claim. So we're going to knock that out because, and I'll just real quick say this, is that I think a lot of people are under the mistaken impression that you can simply just say, hey, this is my opinion, or hey, allegedly, and that just takes care of everything. Certainly it can in some scenarios, but as we'll see today, we really need to do some deeper thinking than just relying on that, in my opinion. Then we're going to look at what is the difference between a private plaintiff, a public figure, a public official, a limited purpose public figure, and an all-purpose public figure, because that assessment determines what level of culpability a defamation plaintiff must prove, whether it's negligence, whether it's actual malice, reckless disregard, these things, right? And then that fits right into the next point we're going to discuss is what is a matter of public concern, because whether or not a statement involves a matter of public concern also affects the level of culpability required by a defamation plaintiff to prove. Okay, so we're really going to look at those three concepts because they're very important and they really determine what kind of case a plaintiff or potentially a defamation defendant might be looking at. So why this matters, and I just had this written down here, but yeah, you want to be able to look and know whether certain statements or allegations are even going to be actionable or not, and if so, to what degree. And then, we're going to look at whether or not TPUSA is a public figure, a private plaintiff, what category does TPUSA fit in there? Because obviously that'll mean, what level of culpability would they have to prove if they were to go to court against one of us. And then we're also going to look at these issues of Charlie Kirk's unaliving, of TPUSA investigation. Are these matters of public concern? Because again, that also will reflect on the kind of case that TPUSA would have to prove in order to actually hold one of us liable, accountable on these.
And in their case, for sure, it would be a matter of public concern, being that they're a nonprofit and they're literally subsidized, through tax dollars.
Okay. Before I get too far into that, there were two things I wanted to discuss. And one is this, and I think this will be very important for people to understand. Someone who republishes, yeah, you've heard the caveat allegedly so much this past month. One of my favorite content creators, 5149 James Lee, it's like he's got like merch that says allegedly, and he like finished it. He's done a really good job at like fitting it into his content and making it pretty comedic, So hopefully James will see this and get a little bit out of this. And James, feel free to ever contact me if you ever want to talk or have about this or anything, for sure. But yeah, so someone who republishes a defamatory statement can be held just as liable as the original republisher. Okay, so ladies and gentlemen, when you're seeing on X or YouTube or these social media platforms, whenever you are reposting stuff that people have posted, or anytime you're repeating something that is defamatory, you potentially could be held just as liable as the original publisher of that statement. It doesn't matter where the defamatory statement or content emanated from, essentially, is what I'm saying there. So hopefully that makes sense. So just be aware of that. I want to talk real quick about anti-SLAPP statutes. So what does that mean? So against strategic lawsuits against public participation. So what this is, and these are state laws, okay? And as far as I know, every state has one of these, but these are state laws designed to give people like me or Wolves in Finance, smaller citizens who are out there speaking consistent with their First Amendment liberties, an avenue to get a very quick and cheap and efficient dismissal of a defamation suit, right? So if someone who's big, powerful TPUSA, this is all just hypothetical conjecture, by the way, but if some big, powerful TPUSA sues Wolves in Finance, I don't know his financial situation, but from what I took from his video, he's not super wealthy or have tons of attorney. Oh, you like that, Linda, about the republishing? Yeah, I figured y'all would like to know that. Yeah. But yeah, so the SLAPP statutes are designed to help protect people like Wolves in Finance, who, again, this is just a general opinion from what I've seen, who is otherwise engaging in protecting First Amendment activity from getting beat up in the courtroom and having his speech, his free speech rights trampled on just because you don't have enough money to pay a lawyer. Because that's essentially what can happen, right? Is that people can otherwise be speaking congruent with their First Amendment liberties, but because they don't have the money or the resources to hire the lawyers to defend them, someone like TPUSA could literally prevent them from exercising their religious freedom.
That's exactly what they're counting on. They're hoping that people get these cease and desist letters and just freak out, get scared, and go out there, say I'm sorry, and shut up and not ever talk about this again.
Just because they have money and the other party doesn't. And so the anti-SLAPP statutes are meant to provide a very stop a bunch of discovery or a bunch of litigation, provide a very quick and efficient means for an individual who receives a cease and desist letter, or who's been sued, might I say, to show up, file a motion to dismiss, and if the speech fits within the categories elucidated in these SLAPP statutes or in the constitutional jurisprudence, then they can easily get it in proper cases, get it easily dismissed without having to spend $100,000, $200,000 in attorney fees. Okay, and so the other night on Barron's live stream, he was talking about the letter to Wolves and Finance and the fact that they didn't even include like direct quotations and stuff like that. Okay, because anti-SLAPP statutes normally require very detailed notice be given. And not only that, it also requires that not only, and so that's where the cease and desist letter comes from, right? These statutes require that before a party or a plaintiff like TPUSA can either collect damages or in some instances collect like punitive damages, they must give notice, very detailed notice, and a chance, 30 to 60 days, sometimes longer, for that individual to retract, correct, and in some instances even apologize in order to avoid litigation. So if they don't have a chance, if they're not notified and get an opportunity to cure the defamatory content alleged, then under most, as far as I know, maybe all SLAPP statutes, someone like TPUSA, hey, Elena, very nice to see you here. Thank you very much. Yeah, so it would just, TPUSA wouldn't be able to collect damages and or punitive damages or, exemplary damages if they don't follow the notice and cure protocols like the anti-SLAPP statute. So for instance, in Wolves and Finance situation, I don't have it in front of me, but I'm almost sure Arizona will have some type of anti-SLAPP statute. And so TPUSA would need to comply with whatever that statute requires as far as notice and cure provisions before they file suit and can collect damages. And Barron mentioned the other night, and maybe he's right too, is that maybe there's some SLAPP statutes where you can't even file the lawsuit, meaning you wouldn't even have jurisdiction. So there's probably some of those too. I know like in Texas, it's really just relates to damages, but it's one of those things where, well, hell, if I can't collect damages or, punitive damages, appropriate damages, why would I even file a lawsuit? So that's why he was talking about the notice and the
I'm sorry, I didn't realize the video was that bad. I listened to most all of it, so I didn't realize it was that bad. But there's still some really good information in here. So
text, essentially a notice to Wolves and Finance because there were no direct quotations. And you see in his video the result of that, right? The man's literally having to try to guess what it was that he said that was, offensive to them. And so SLAPP statutes don't want that. They want people to have a definite idea, understanding of what it was that's defamatory, what it was, why it's defamatory, and give them ample opportunity, 30, 60 days to cure that default if they agree that. And so when we see with Wolves and Finance, right, he's amenable to correcting and stuff. So based upon Wolves and Finance attitude and the content, it's my opinion that they would have a very hard time suing him. I don't think that, and we'll get to this in a minute, but the burden of proof, they have to show actual malice and just his attitude and stuff like that. I don't think they're going to be able to do that. And we'll talk a little bit more about that in a second. But yeah, so these anti-SLAPP statutes are important, especially for what we're doing, to understand that they exist, to understand what they require. And, along those veins, if you're making content doing stuff like that, just one, don't ever intentionally publish false stuff. Do as much research as you can. Feel good in the truth of what you're saying. And three, just remain amenable that if you're wrong, to potentially correct it and be okay with it. And you that can make you hard to sue for defamation, right, with these anti-SLAPP statutes. So that's kind of three things that you can do no matter what that can help protect you against defamation lawsuits. Elena, what is the advantage of not directly quoting him? It makes them look shady and they'll have to provide specifics in a case, right? How can he cure what they're accusing him of? Specific? No, exactly what you said. As I pointed out just a second ago, it's yeah, without the specifics, you can't really technically cure it. They would have a very hard time because yes, when you go to court, absolutely. Yeah. If you file a lawsuit and there's not enough detail in the complaint for the judge or the court to really understand what it is you're suing on, well, then that can be dismissed, right? Failure to state a claim upon which relief can be granted. So yes, if they went to file a lawsuit, they would have to very succinctly state what it was that was said, it's defamatory, and what damages were caused because of that defamatory content. And Rolls, thank you. You're doing a great job. Close to 500 subscribers already. Nice. Yeah, man. Thank you. It's been great. I'm very blessed and honored. To date, my subscribers have been incredible. With just, like I said, it can be dense, it can be difficult, and it's very nuanced. And so normally in the legal field, in the legal industry, there's usually very specific attorneys that specialize in things and evolve around the First Amendment. So I'm generally competent in defamation law. So did they research it enough? I don't know. I can say this is maybe perhaps he didn't understand that. It seems to me that this might not be a lawyer that's necessarily well trained on defamation, and that might be why he failed, or the person failed to adequately describe it in my state attorney. But when you go to the point of saying, oh, if you don't do this, then we're going to file a lawsuit, that's practicing law in another state, and that's where he crossed the line, as Barron pointed out. Why? And so let me get back to your question real quick. So why do I think they did this? I mean, really just to scare people, I do believe. I think it was, again, just my opinion, and this is just
100%.
purely speculation. I certainly don't know this as a fact, but probably just as a scare tactic, because look, we don't know what all they got going on there. We don't, because there's a lot of internal documents and contracts, things of that nature that we have that we would need to really come to some hard conclusions on a lot of the more, defamatory, the more damaging type conclusions of fraud, things of that nature. So, if they're actually engaged in stuff like that, and I know I said this on another stream and probably one of my videos, but it's like, if discovery gets opened up, so it would be their duty to prove falsity. Okay, so they would have to prove that what Wolves in Finance said was false. So in order to do that, they would have to pull out the documents and stuff that we've been asking for quite some time to do that. So it's very interesting to think, well, if they don't file suit,
And think about that in the case of Candace. Think about all of the things that that she has discussed, and think about if they brought a lawsuit like this, how they would literally have to prove that what she said was incorrect, and that she knew it was incorrect and said it anyway to damage them. And that's where that whole discovery can be a bitch comes in, because, if they have really done something wrong, then when it comes time for discovery, not only are they not going to be able to prove that she lied, but she is going to, it's going to then be public and on the record of any illegal things they've done. And this would apply to anything that happened, leading up to September the 10th or after. So, that's opening up a can of worms, I feel like. And maybe not, maybe nobody had anything to do with anything, but I don't know. I feel like there's a very small chance of that.
Again, this is just speculation, pure speculation, hypothetical theories. In a hypothetical situation, it might be okay to assume that if they don't file suit, that might mean that they don't have the evidence needed to prove what Wolves in Finance said was false. This is just speculation. I don't know that for sure. So again, and that kind of factors into what, why they're doing this. But ultimately, I'm going to rest on my opinion, pure speculation, hypothetical, being that this was just simply a scare tactic and was,
Just imagine Candace Owens being turned loose with full access to, all of their records when it comes to a particular thing. I mean, she would have a heyday.
Him going online and announcing it to all the world on YouTube was exactly what they wanted to do. Now, what I don't, again, my opinion, speculation, what I don't think that they accounted for was people in the community being willing to step up and support Wolves in Finance, that there were some of us content creators out here who do know what we're talking about with defamation law and stuff like that, and ready and willing to educate the public here and show up and support Wolves in Finance if need be. So I don't think it's gone how they were maybe intending it. And again, this is speculation. I don't know this, but it seems to me like this might have been one of those instances, like a hypothetical scenario where someone goes and wants their lawyer to do something, but the lawyer's like, I don't know if that's the greatest idea, to do that, but they just insist. And those video the other day, I mean, just off the top of my head, I can think of about 10 to 20 discovery requests I would like to send that I think would be pretty powerful as far as eliciting information. Seems to me with an entity as large and well-funded as TPUSA in Indiana, so that's like where their official corporate headquarters is. Simply saying this is my opinion, stuff like that, doesn't necessarily escape a defamation claim. And so we'll jump into that in just a second, just so we can kind of sort that out. But yeah, now it does help. Ultimately what the court,
At the end of the day, if you're just saying allegedly first, this is my opinion or what have you, they could still sue you. And if it got that far and it got to discovery, if they could prove that you knew what you were saying was false, but you said it anyway and just threw an allegedly on the front, then they got you. So that's more or less what he's saying there. I mean, if you say something and you believe it to be fact, but you're worried about being sued, definitely allegedly helps. And that is if you legitimately don't know any different. But what he's saying here is if you do know different, if you know that what you're about to say is factually incorrect, then it's kind of dangerous to throw an allegedly on the front and assume everything's all right.
what's going to look at is what a reasonable listener in the audience perceived. And so as long as the audience isn't perceiving that you're stating, for instance, like with Wolves in Finance, like I don't think anybody really took what he said as like 100% proof without a doubt that these people are committing fraud. I think everybody understood that he was reporting factual information.
No, and what he reported as fact were the facts that were on the filed income tax forms. So what he reported as fact is just what's in black and white on their forms. And then he asked the question, why? You know, is there some shady business with this? Looks like there could be. Is it necessarily illegal? I don't know. Is it ethical? So, you know, and look, Candace has been the same way about a lot of the stuff that she said. But you know, the only thing that he reported as fact were the actual facts, and then of course there's questions after. I mean, understandably so. We've all got questions, and it's about time we got some of them answered.
And then like even in the video, he's just kind of saying like, hey, based upon what aligned on seeing this through for truth and justice. Nothing has gone the way they intended. It seems they thought we would carrying out a public thing like that is ballsy. I mean, it's just ballsy. And I think we're seeing now that things didn't go, like you say, as they intended. And now we're seeing the, damage control. And, that damage control is egregious, like covering.
It has been damage control since probably started about 1 o'clock on September the 10th, and been damage control ever since.
Over the, paving over where this happened at, stuff like that. We're looking at, filing a notice of a speedy trial as a victim representative. So yeah, we're just seeing a lot of this error correction is almost as egregious as the original instance in some ways, right? So I hate it, and here we are. But it's.
And speaking of that being paved over, I don't know if anybody's heard this or not, but and I don't know if everybody's familiar with Sheriff Mack, but Sheriff Mack is he's a real good follow, super smart, super good guy. He was a sheriff there in Arizona for many years, and he is one of the constitutional sheriffs, and he heads up that organization. But regardless, so I seen a clip with him talking to somebody, but he was saying he had a discussion with the head prosecutor for Utah, and asked, "Do you know that they paved over that place where that happened, just a few days after the fact?" And he said no, had no idea, was shocked. So, maybe it wasn't illegal, but when the head prosecutor even can't believe it, I mean, that was a wild move. And I just forever will think that there was a reason for that. I don't know. It just, I don't think they just decided to do that for no reason.
Super important. One of the reasons why I jumped on to YouTube on this topic is just there's so much here to educate the public, to point out to the public of what has gone wrong in many ways with this country, with a lot of things. And so again, that's kind of why we're here today too. Just kind of reading the comments, really enjoying content, hearing things about the legality of these subjects is needed. Oh, thank y'all very much. Yeah, and I'll say this caveat too is that these are just y'all are probably aware, law is gray day, regardless of whether you make a defamatory statement or not, as we'll see with like public figures, things of that, like the burden that they have to prove that like you had reckless disregard for the truth or like you knew it was true, it's a very high burden. So like even if things that you state accidentally come out and are defamatory, unless you had some real specific bad intentions with that, they're probably not gonna be able to prove their case. Okay. So anyways, I hope we're kind of at a good spot now. Again, it's my first live. So anyways, let's keep going. So what is an actionable statement? For that, I did some bullets here. And again, if anybody wants this outline, I put my email in the description. Feel free to reach out because I don't have screen share right now. I'm still working on integrating OBS. But I do have this outline. I'll be glad to send it to anybody who asks. But so let's talk about what is an actionable statement under defamation. But before we do that, I'm going to talk about what are the elements of a defamation claim. Okay, so meaning what does a person who wants to sue another for defamation, what do they need to prove? Okay, and so these elements came out of my Texas Forms book, but because of the constitutionality in the defamation paradigm, these are going to be pretty much the same state to state. So let's talk about it real quick. So you have to have the defendant publish a statement of fact, that statement of fact referred to the plaintiff, that the statement was defamatory, that the statement was false. And so we'll talk too is that pretty much 90% of the cases, the plaintiff, so in this instance, TPUSA would have the burden to prove that what, for instance, Wolves and Finance said was false. And Wolves and Finance will always have truth as a defense. So in that scenario, if there's a lawsuit going on and we're talking about discovery, Wolves and Finance is going to be asking for documents to try to prove what he said was true. TPUSA is going to be trying to produce.
And they'll have to turn those documents over if it makes it to court. If they do actually sue them, they'll have to turn any of those documents over to Wolves and Finance. And I have a feeling that might be a bad mistake. And I also feel like that is, or that is why I feel like that this is a scare tactic, and I just don't know that they would ever see it to court. Um, I could be wrong, but a lot of people smarter than me have been looking at those finances, and just really seems odd, some of the stuff that's been going on.
Documents to prove what Rules and Finance said was false. So you kind of have like that double effort really at the same thing. And so it would be right. So it would be extremely interesting to see the discovery process in a lawsuit between TPUSA and Rules and Finance. I mean, I could probably do live commentary just about the document exchange back and forth and stuff like that. It would be, I say it'd be funny. It wouldn't be funny, but it would definitely be informative and educational. Let's see. Been busy, but is Zach doing okay? Who you're busy, but is Zach, where we're trying to get documents, you're asking questions. This includes depositions, requests for admissions and stuff. And so in this instance, in the defamation claim, right, we've all been kind of looking at and investigating TPUSA for, again, there's allegations, stuff people have in their mind that potentially there's fraud, things like that. And so the discovery process, there's a lawsuit, would open it up to where Rules and Finance would have a legal right to ask for documents that we don't otherwise have access or a legal right to access right now, including board minutes, contracts, things of that nature. And so that's why we've been talking about the discovery, because
and hence a lawsuit would be good for us, the general public. We would get to see a lot of stuff that more than likely we will never get to see otherwise.
If it went to discovery, it would be an opportunity for the community via Zach to really pull documents and other things that could help our investigation, help what we're covering here on YouTube. So discovery is just the process in litigation and lawsuits where parties ask each other for evidence, whether it's statements, questions, physical evidence, stuff like that. It basically is where we would have a legal right, where Zach and Rules and Finance in that hypothetical situation would have a legal right to ask for those documents. And so that's why it's kind of material to our discussion here because of the larger investigation that's going on with TPUSA. Would we get to see what he finds in discovery? I mean, theoretically, yeah. So discovery generally isn't published in the public record, but that doesn't mean that it's not protected from disclosure. So unless a judge in a lawsuit placed a specific seal or some type of discovery order preventing any of those things that are exchanged in discovery from being disclosed, then no. And ultimately, regardless, is even if Zach was not able to disclose things he learned in discovery during the pendency, towards the end, whenever they file their motions, whenever Zach would file a motion saying, hey, they don't have a claim because XYZ documents prove that they were, committing fraud. That's all hypothetical. I'm not saying they're fraud, but that's just a hypothetical situation where that could definitely occur. So we definitely could potentially see what Zach finds in discovery. And without a question, if it goes to trial and those things are produced into the court record publicly, we would definitely see them then. But when discovery occurs and documents are exchanged, it doesn't automatically go into the public record. And whether Zach could disclose those things to us would depend on several different things. But either way, obviously, if Zach's doing discovery stuff like that, we at least in a roundabout way would know what's being discovered, things like that, as we see the lawsuit progress, right? Because if Zach didn't uncover anything that indicated fraud, well, then he would end up losing the lawsuit theoretically. Again, that's all hypothetical, not legal advice, not stating anything definite or factual about TPUSA or anybody. Do I know Baron? Depots? Yeah, so depositions. Again, so deposition is just pre-trial. For a couple things I'd found along the investigation. I've never heard from him or spoken with him. I'd love to. Justin Maldoni's. Sorry, I'll write this down. Yeah, like I say, defamation's kind of a niche area of law. It's very nuanced. And so really, if you're going to hire a lawyer for a defamation case, try to get a specific one, because again, there's a lot of nuanced stuff. And when you got an area of law with a lot of nuance, you really want someone who specializes in it, because it can get real hairy real quick. And so the religious work I do, I mostly specialize in freedom of religion, protecting free exercise. It's very niche. There's not a lot of lawyers that really specialize in it. And why is that? Well, there's a lot of nuance to it. Really, any constitutional law is going to be pretty well nuanced. They would try to protect the discovery from disclosure preemptively. It would be amazing to see information we've been wondering about. Tyler Boyer is quaking in fear. Barron really opened my eyes a bit last night with his live stream talking about, the evolution of TPUSA, and it really jives with some of the stuff I've researched. But I'll show you why I'm talking about a lot of stuff they're doing is very destructive for our country, unfortunately, ladies and gentlemen. Again, in my opinion, but I'll definitely reveal what I'm talking about. I'm in Western North Carolina. Me too. Just starting here. I hope we have keep electricity. Yeah, me too, love. I'm in the Nantahala National Forest. Oh my goodness, Justin Baldwin, Engelbeck lively cases. So many parallels to this, including CIA connections. Sweet, I've got it written down. I'm definitely going to go look into that either tonight or tomorrow, and we'll report back. Thank you for that, Elena. And I hope you stay safe here in the mountains here. So TPSA would know they're opening themselves up to risk by entering into a case of discovery. Potentially, yeah. I mean, I would hope they would think that. I hope they know that. I hope they got a lawyer that would tell them, hey, if we file this lawsuit, we'll be opening up a can of worms. So just understand that before we do. So yeah. Let's see. Oh, Scotland peeps, Lizard, what's up, man? Baron is ace, man. from Scotland. Yeah, and I've got people from Denmark, also Christian, or whatever moral, authority that they cling to, but like actually living what that authority requires. Let's see. That it was false. It generally have to prove. Yeah, thank y'all. I appreciate it. Yeah, so let me kind of get back to where we were. So again, I read so real quick, I was going through the elements here. So we had, the statement has to be defamatory, it has to be false, and then let's talk about falsity. So with regard to the truth of the statement, okay, so this is what would TPUSA generally have to prove in a defamation claim? They'd have to show that Rules and Finance published some statement of fact, and we'll talk about that in a second, that it referred to them, that it was defamatory, that it was false, and that with regard to the truth of the statement, Rules and Finance either acted with actual malice, that he was negligent in regards to the truth, and we'll sort these out in a minute, or in some instances, there's actually strict liability for defamation. And those are very rare, and maybe not all states even have that, but they do in Texas, but very rare, and we're not in the strict. And lastly, they would have to show proximate cause or damages. They would have to show, hey, this statement caused these damages, right? And then that gets into, well, if it's your reputation that was damaged, obviously there's not like a number on reputation where we can gauge how big of a hit your reputation took. But if it's a business, things like that, you could show tax returns, lost wages, things of that nature. In some cases, damages are presumed. Now, it's not going to be these cases that we're going to be talking about today, but you understand what I'm saying is that, you have to prove damages. You have to prove that this statement caused the damages. So in the instance of Rules and Finance, so, he's not the only person out there that's made similar videos, published similar videos with similar factual statements, conclusions, stuff like that. So if they were to go to trial, potentially, if TPUSA doesn't add in everyone who's made a similar statement to that effect, or Rules and Finance doesn't try to add some of those people too, the damage thing could get really quirky, right? Because if they're saying, hey, Rules and Finance caused these damages, but there's been other content creators making substantially similar remarks, well, how do you know it's fairly attributable to Rules and Finance? So again, I'm not going to go down that rabbit hole and start sorting.
And again, I say it's going to be hard to prove anybody or any group of people caused any damages when they raked in 2.5 times what they normally rake in since September the 10th. So, yeah, I think that right there will probably, I think that would throw a monkey wrench in it.
All that out here for you, but just to understand that it can get real hairy real quick. These are not straightforward claims and can be very difficult to prove. And so just wanted to highlight that, especially in an environment like this, where you have so many different content creators. This isn't like it used to be, where you have just like NBC, ABC, CBS, making all the statements that make it to millions of people. Now you got a lot of people who make statements and make it in the same vein as exactly what Rules and Finance has been saying. And then you get also too, right, republishing. If it asserts or what constitutes a statement of fact. Right, and this is going to be the Milkovich, is a U.S. Supreme Court decision from 1990, but they said, a statement is only actionable if it asserts or implies, okay, also implies objectively verifiable facts that are false and defamatory. So the implication is important for this reason, right? Because if you can imply an assertion of an objectively verifiable fact, that means that if you say, oh, Jones is a liar, or it's my opinion Jones is a liar, well, you're still implying that there's some type of factual basis for your opinion. Okay, so that could still potentially be actionable. There is no fact versus opinion dichotomy. An opinion, like any other statement, can be actionable in defamation if it expressly or impliedly asserts facts that can be objectively verifiable. And so let me just stop right real quick and say, you understand now that, like, does a statement imply verifiable facts? It can get very dense on the analysis in defamation claims. Okay. And that's why I'm not going to stop and go through all these different claims from like TPUSA. Well, for one, we don't know specifically what some of them even are. But two, it would just be we could sit here and do hypotheticals all damn day. It'd still be just as confused at the end as we were at the beginning. So let's see, these comments. We were rooting for you from all the way across the water. For sure. Thank you. There's a lot you need to prove. Yeah, very difficult case. TPUSA, for these purposes at least, is at the very least a limited purpose public figure. Jones is a liar implies knowledge of facts that lead to the conclusion that Jones is a liar. So that, again, very well could be an actionable statement. Simply couching a statement in terms of opinion does not dispel this implication. So how does the court determine whether a statement is objectively verifiable as fact as a matter of law? They look at least in Texas. So this point right here, this is what Texas courts generally look at. Again, I would suspect that this would be very similar to what most other state courts look at, but just want to give that caveat here. But what do Texas courts look at to determine whether a statement is either asserts or implies an objectively verifiable fact? They look at the factual setting in which the statement was made, a political, social, or scientific debate. And the reason for that is that some contexts lend themselves to people playing around or joking or not taking people as seriously as others, right? If we're hanging out on the back deck by the pool talking is going to be a little bit different context than if I'm at the Democratic National Convention or something like that giving statements, right? So they look at the context. They look at the format in which the statement appears. So an editorial, blog post, website, newspaper, telephone conversation, Zoom meeting, live stream, that matters. The general tenor of the entire work. So for Rules in Finance, they wouldn't just look at and I said this on a live stream the other day with Mr. Let Go and Danks. They wouldn't look just at the thumbnail where it says fraud with the question mark. They would look at the entire video and look at the gist and say, what would the average reasonable listener or viewer take away from this video? And then that kind of sets the last one, the reasonable expectations of the audience in that particular situation. Would they expect this person stating straight up facts to them? Would they expect, like in Rules in Finance video, that, hey, he's saying facts, but like ultimately, what he's saying with regards to frauds, really just his interpretation of it. So again, they look at what the average reader, listener, viewer would be taking away from the entire work. Courts will determine whether a reasonable listener or viewer could have concluded the statements were conveying facts about the plaintiff, and then whether the statement is actually injurious to the reputation. Let's see real quick. I'm going to read real quick, ladies and gentlemen, just real briefly from the book here. It explains it a little bit more because I don't want to just leave kind of haphazard this thing of what is an actionable statement. So let me just read some of this real quick. And some of it I've already covered here, but it adds a little bit. But they say the test, so looking to see where it's either impliedly or expressly asserts a verifiable fact. It's the plants of the former analysis. So there used to be a distinction between fact and opinion. But like I said, in this Milkovich case in 1990, the Supreme Court did away with it and said that, this whole opinion thing doesn't necessarily protect you if it implies certain facts. If the speaker states the facts, on which she bases her opinion, and those facts are either incorrect or incomplete, or her assessment of them is erroneous, the statement very well may still imply a false assertion of fact. Simply couching a statement in terms of opinion does not dispel this implication. Let's see. Implication. Thus, whether a statement is actual in defamation does not depend on whether the statement can be categorized as opinion or fact, but on whether the statement can be categorized as fact or non-fact. The court determines whether the statement is objectively verifiable as fact as a matter of law. So again, not open and shut case, ladies and gentlemen. I guess that's one of the main things I want everyone to take away from this. I'm not going to get super dense into the weeds here, but just understand that just saying it's your opinion, stuff like that, does not shield you necessarily from defamation action. And so it can still imply an assertion of underlying facts. So that's the main thing I want everybody to understand, is that the allegedly, this is my opinion, stuff like that does not necessarily get you into the safe zone. I'm not going to speculate here because there's so nuanced. What would you do instead, or what could you say instead? Again, because it is highly nuanced, it's very situationally dependent. And so therefore I don't want to go into that speculation. If people absolutely want to learn and dive deeper into that per se, just shoot me an email. I can shoot you some materials and stuff like that. Definitely read up. Maybe we can have a conversation about it. But I'm not going to go super deep into the speculation or tell people do this, don't do that in these regards, because I don't want people to get emboldened or brazen to do stuff that would be stupid. So anyways, sorry about that, but I'm going to leave that there. Certainly I can speak with people, or if there's a large public outcry to know more, I can do another live stream or video and go a little bit further into it, but I'm going to leave that one there for right now. So thank y'all. Yeah. And again, it gets difficult and dense too. Y'all don't want to sit here and exercise your brain like that today. Trust me. So now we're going to transition into the next, and this is really more important anyways for talking about TPUSA and defamation, is what is a matter of public concern and why does that matter? So I'll say one real quick, and it might, this might already kind of.
Anything related to TPUSA is a public concern, especially since September the 10th. But again, they're subsidized by tax dollars. They are completely funded out of people's pockets. So it would definitely be a matter of public concern in their case.
Register with you, but the First Amendment is intended to protect a marketplace of ideas. And, so that way our government, our society can advance forward, presumably the best way possible, right? And so the theory being that the more ideas that we have in this marketplace of ideas, and specifically in certain categories. So again, speech has certain value to it, right? So it's like me talking about what Kim Kardashian, what kind of eyeliner she used today, is much less of a matter of public concern than did TPUSA do something fraudulent as a publicly subsidized nonprofit. And so on the spectrum of First Amendment, someone speaking about the TPUSA thing is going to be more likely to have protection, be protected from a defamation suit, than someone talking about something like Kim Kardashian's eyeliner. And that's, for some people this is important, I get it, but we're talking about what's a matter of public concern, meaning the overall general public, what level of concern is a subject matter to them will be a factor to consider in the level of protection given to the speaker in making the statement. Okay. Our First Amendment protects matters of public concern much more vigorously than it does matters which we tend to think are senseless or brainless. Okay. That makes sense. I'm going to check comments real quick now. We've kind of segued. Do you think give a chance to, do they have to give you a chance? Yeah. So Lizard. Yeah. And so that's what I was talking about with the anti-SLAPP statutes is that you're not going to have a successful defamation lawsuit in most states unless you give appropriate cease and desist notice prior to filing suit. I hope that helped. TPUSA push forward, then could Zach get access to that's a very good question. It would just depend on how that litigation plays out. Obviously, Zach's lawyer would need to make an argument as to why Tyler Boyer, Rob McCoy, or these other financials are relevant to the analysis, to his defense. I'm not going to go into that argument potentially here because we don't have everything we would need to really fully assess it. But yes, that definitely the argument could be made, and it would be up to the court to determine whether that's valid or not. And how about receipts or donors like Olympic Media LLC to make sure they receive funds and where they went? So yeah, again, that's along the same lines. If Zach's lawyer in this hypothetical could make the argument to the court why that's relevant and essential for his defense, then yeah, absolutely, you could potentially get access to it. Now, it would be harder in the sense that because Rob McCoy, Tyler, and them aren't necessarily a party to the suit, you would have to have like a subpoena, stuff like that. You wouldn't be entitled to that as a matter of right because of the discovery. More than likely, you would need to file a separate motion, get a subpoena and stuff like that. So it would not nearly be as straightforward as just getting documents from TPUSA, but it is within the realm of possibilities that possibly those could be acquired and part of the record. Aloha from Hawaii. Sending warm wishes. Everyone faces severe winter weather on the mainland. Here, the Kona winds are keeping things more pleasant, 78 degrees. Oh man, that sounds incredible. Like industry standard. It's like the rate they were taking. It seems to be a bit against just allegedly. It seems that the rate they were taking was above industry standard. So there looks to be potentially some things there to definitely be investigated. I'll just leave it at that. And so could that potentially be part of the, those documents? Well, certainly internal documents that TPUSA has related to the Stacey Sheraton deal would be fair game, but like documents from that company, their side of it could be discoverable. Again, it's just all my equipment and podcast studio set up to record, doing more live amount. And she's not on their tax records as being employed, even though she still works there very strange. Yeah. So again, those things, we would love to see some more stuff. We definitely would. And, Wolves and Finance litigation might be the opportunity to grab some of that stuff. Back to what is a matter of public concern. So the statement can be fairly considered as relating to any matter of political, social, or other concern to the community. And this is Snyder versus Helps, 2011 Supreme Court decision. Determine whether a statement involves a matter of public concern. The content, form, and context of the statement must be analyzed, including just like it is with, was this an assertion of fact? They look at the full context. Same thing with matter of public concern. We look at the context, including what was said, who said it, and where it was said. So public concern, well, what is private concern? Well, a matter is of purely private concern if it is solely in an individual's interest. Okay. So it's like this, the issue of whether, you swept your porch this morning is obviously purely a matter of private concern because the resolution of it, whether you did or did not sweep your porch, really only affects you and your family, right? So very small. Whether TPUSA, a publicly subsidized entity, has been doing certain financial transactions in, that contravenes the tax laws, then that obviously affects all of us, right? Our tax dollars have gone to help TPUSA remain tax-free and be subsidized. And so their compliance with the tax laws and any laws really is most definitely a matter that affects all of us, even if it's just tangential.
And it's kind of abruptly. I don't know what happened there. I guess he hit I don't know, maybe he lost internet. Anyway, he was wrapping up. So let me, there we go. So I thought that was very interesting and enlightening. Yes, I feel like Wolves in Finance could probably drag up some pretty good stuff if they do get into a lawsuit with Turning Point over this. But if any of them goes to court, I'm really hoping it's Candace. The allegations in Candace's are more broad. With Wolves in Finance, with Zach, his is more directly, the financial stuff, certain comments he made on the financials, and that's all that I know of that he's really commented on. With Candace, it was a lot broader. I don't know that they even brought up financials directly in the letter. I know one of the things, which is stupid, was her list of lies that have been told from Turning Point or people associated. Either way, her letter was much more broad, and so if it ends up going to court and they end up having discovery, um, she's going to drag up all kinds of good shit um, at the end of the day. I just don't see them pushing it that far. Surely to God, they're smarter than that. I feel like there's just a lot there that they don't want to have to dig up. Can of worms would be an understatement. I don't know. Only time will tell. We'll have to wait and see. I figure they just said, you know what? Screw it. It ain't going to hurt to send a cease and desist out just to see if she'll quit. I I know she's not going to quit, and they probably should have known that she's not going to quit. I doubt it ever goes to court. If it does, that will be interesting to say the least. Um, but I don't really expect to see it go to court. Maybe it will. I don't know. We'll have to just see. Um, didn't seem to me that like Candace Owens was super concerned with it. So I don't know. Well, just time will tell. All right, it's getting late. I wanted to bring that to you. He's a new creator, pretty smart, very enlightening. Uh, I thought that would be a good thing to bring to help him get it pushed out there. And so I could put in my 2 cents worth also. So, all right. I'm going to get off here. I will be back in a day or two. Please like the video. If you're not subscribed, please subscribe and click the notification button. That way you'll get notification when I am live again. And share the video, please. Small channel, trying to get out there, and that's the way to get it out there is for people to be liking, subscribing, and sharing. All right, that's it. I'm going to get out of here. I hope y'all have good what's left of y'all's weekend, and I will see you again in a day or two.